Good afternoon. Good afternoon. Hope everyone is doing well. I'm Jasmine Gonzalez Rose, a professor of law and associate dean for equity, justice, and engagement. I am delighted to welcome you to this installment of the Barbara Jordan Speaker Series on race, law, and inequality for a lecture by Daniel Kiel on his book, The Transition: Interpreting Justice from Thurgood Marshall to Clarence Thomas. Our Dean, Angela Onwachi-Willig, brought the Barbara Jordan Lecture Series to BU Law to foster a deeper engagement with issues of race, racism, and the law. As a leader and a scholar, she prompts us to consider both the law's role in perpetuating racism and the opportunities to utilize the law to mitigate racism. The Barbara Jordan Speaker Series, in honor of the distinguished alumna from BU Law class of 1959, was the first African-American woman elected to Congress from the Deep South. The series is now endowed in perpetuity thanks to a generous gift from Gary Tischler, a graduate of our class of 1987. We are deeply grateful to his generous support, to the law school, and for stepping up to fund this important lecture series that will be beneficial for future generations of BU Law students, alumni, and faculty. We're delighted to be able to hear from leading scholars and legal leaders on issues of race, law, and inequality. It's my pleasure to introduce today's speaker. Daniel Kiel is a professor of law at the University of Memphis, Cecil C. Humphreys School of Law, where he teaches property, constitutional law, and education and civil rights. Among other things, he is a graduate of the class of 2004 of Harvard Law School, which at least two of us in this room can agree was the very best class ever to graduate from that prestigious institution. We have a very prestigious faculty member from that class, Professor Kennedy here, who I don't know if he would agree, but we won't allow any space to affirm or deny that fact. Professor Kiel's scholarly work centers on inequality in the education system, particularly along lines of race, as well as constitutional questions of citizenship and justice. In addition to traditional scholarship, Professor Kiel developed an oral history project that culminated in the Memphis 13, a documentary film he wrote and directed sharing the stories of the first students to desegregate public schools in Memphis. This award-winning film has premiered in the National Civil Rights Museum on desegregation's 50th anniversary and has been featured across the country. Drawing from his recent book, The Transition: Interpreting Justice from Thurgood Marshall to Clarence Thomas, Daniel Kiel will examine how these justices came to their contrasting visions for using the law to produce equal Black citizenship and how those visions have influenced and defined the decades-long remaking of the Supreme Court. Welcome to Boston University School of Law. We look forward to hearing from you.
Thank you very much, Jasmine. Thank you, Dean, for establishing this series. It's been already wonderful to be here. Boston is a place that holds, a very, very special place in my heart. So I just feel warmness being in Boston, which I know is not what normally people report when they're in Boston, but even coming from our warm climate in Memphis to this, I just feel really wonderful to be here. So thank you all for the opportunity. It's also wonderful to connect with a classmate. We have a big school there. And thank you also to my professor for being here and to all of you for being here. So I'm going to begin with a quote that I think is part of the kernel of ideas that gave birth to the study that led to this book. And it is this quote from a dissent from Justice Marshall in a 1991 case, Payne versus Tennessee. And before going into the quote itself, I want to talk a little bit about the fact that this case was important to me even before I recognized that it was the last dissent of Justice Marshall's career. Payne versus Tennessee is a case about victim impact evidence, and the court had was reversing a decision from 4 years prior in which they had said victim impact evidence in the sentencing phase, especially in a death penalty case, was not okay, and in Payne, they reversed and said it was okay in that particular context. And while that's an important case, it's an important case to me because in my early years of law practice, I was assigned a case in Memphis, and it was to seek DNA testing for a defendant that had been sentenced to death. And the reason it came to our firm was because our firm had represented this individual when his case had gone to the Supreme Court in 1991. And so my firm had represented Purvis Payne, and in 2006, I represented Purvis Payne. And so I had read all of the sort of back cases and back opinions. And so this particular case was one that I came across. Didn't know at the time that it was Justice Marshall's final dissent, just knew it as the time that my firm represented Purvis Payne at the Supreme Court. And so as I worked on Mr. Payne's behalf, I felt this distant, but not entirely ephemeral connection to the work of Justice Marshall. In that case, Justice Marshall is in dissent, and he's arguing that the sentencing of Purvis Payne was improper. And here I was, Purvis Payne, 15 years later, still arguing for his, at that point, we were looking for evidence that would lead to his exoneration, but still working on his behalf. And so I felt this connection, and so that was special. And just sort of by way of information, Purvis Payne is actually still in prison. However, due to a recent change in law, he has been declared ineligible for the death penalty, and so he will not be sentenced to death. So the work that Justice Marshall, on his last case, the work that or the outcome that he was hoping for, which is not to have Purvis Payne executed, has been successful. So that's the connection to this particular case. But what I think makes it relevant for these purposes is the discussion about how personnel matters on the court. So this quote, neither the law nor the facts underwent any change in the last 4 years, only the personnel of the court did. There were 2 Supreme Court transitions in between the prior case and Payne versus Tennessee, and Justice Marshall is lamenting that change in personnel means we get a different outcome. And that is a really dangerous idea, that the court is influenced not by law or reason, but rather the court is influenced by who is on the court. We all, as lawyers and as professors and law students, know that to be true. Justice Marshall is saying the quiet part out loud here and saying that's what has driven this particular decision. And why I think it's particularly poignant is because later that afternoon, Justice Marshall delivered to President Bush I his own resignation letter, or retirement letter. And so in this moment where he recognizes the importance of personnel on the court dictating potential outcomes, he is also going to contribute further to the changing personnel on the court. And so it is, I think, just a really charged thing to write on a day when you know that the likely outcome of a successor nomination, and we all know that to be ultimately Clarence Thomas, is going to be to push the court in a different direction as well, that the personnel in the court is going to change and it's going to result in change in law. So the book is about the transition from from Thurgood Marshall to Clarence Thomas, but it doesn't really focus on that particular moment in 1991. But I do want to highlight a couple of things that are present at that particular moment in 1991. And so this is a moment a transition in particular, that is hugely impactful. In fact, I'll argue that it's the most impactful transition from a Supreme Court justice to a successor of at least the last 70 years. So it's an ideologically impactful transition to lose Justice Marshall and gain Justice Thomas. But it's also, as we all know, a moment where Supreme Court confirmations become something new. The sort of media is in a different phase. We're getting into sort of the CNN era of media, and so we have a new way of doing Supreme Court confirmation hearings, and they become sort of these 24-hour news events like we know them to be today. And in addition, of course, this particular confirmation hearing occurs in a moment where sexual harassment in the workplace becomes elevated into the public consciousness in ways that it hadn't been previously. This talk is not about those particular elements of this particular transition, but I just want to acknowledge that those are big things that are happening in this moment as well, and others as well. One part of this that I do want to spend some time talking about is the way that this particular transition stands apart from every other transition, in that this is the only time we have had a transition on the court in which the departing justice has been an African-American justice. And so 1991 was not only ideologically and politically and from a media and social standpoint and with regard to sexual harassment a big moment, it's also fraught with race. And at this particular time, we're in a moment where, as always, race is relevant. Race is front of mind in a lot of public conversations. The Supreme Court is trying to decide whether affirmative action triggers strict scrutiny in the same way that explicit racial discrimination would trigger strict scrutiny. So that's kind of an open question at this particular point. Maybe it's getting close to settled, but certainly the appointment of Justice Thomas confirms that. The other thing that's going on, especially in the employment discrimination area, is that there are discussions about the extent to which quotas or other sorts of incentives for hiring ought to be a part of remedies to employment discrimination claims or things like that. And President Bush, in fact, had just vetoed a civil rights bill that said, you can't have people making decisions based exclusively on race. I think that this civil rights bill in 1990 too incentivizes people to take race into consideration. And so he vetoed that bill, and the sort of rewritten version of it passes as the Civil Rights Act of 1991, but I just sort of am emphasizing that these are topics of conversation. How much should race matter in filling jobs? And so another quote, which I'm going to show a little portion of a press conference that occurred around this time. I think a lot worse things have been said, Clarence Thomas said, in reaction to a question at his press conference. But I wanted to note the trickiness with which race was playing a role in not just employment generally, but in this particular employment. We have a job opening, the nation's first Black justice being replaced or being nominated to be replaced, and complex circumstances, complex thinking with regard to race. Justice Marshall had spent his entire career saying race matters. Race is a relevant factor that should be considered, whether we're talking about employment, whether we're talking about, his entire life, he had been breaking barriers himself, right? He had broken the barrier into the Supreme Court. President Bush, on the other hand, and Clarence Thomas during his time at the EEOC is saying, no, we don't want race to be too much of a factor. And so there's this conundrum in this moment where sort of Justice Marshall is saying, who has a career of saying race should matter, he's going to say what he's going to say, which I'll show in just a second. And then President Bush, who's been saying, no, race isn't a factor or shouldn't be too much of a factor, is now pretty clearly utilizing race and sort of threading the needle that he has before him by nominating a Black conservative judge to fill Justice Thomas's seat. So rather than me say what they said, I was going to show a couple of clips here that take us back to 1991. So this first one is from the press conference that Justice Marshall held the day after Payne versus Tennessee, in which he met the media to discuss his retirement.
Do you think President Bush has any kind of an obligation to name a minority candidate for your job?
I don't think that that should be a ploy, and I don't think it should be used as an excuse one way or the other.
An excuse for what, Justice?
Doing wrong.
Marshall, when did you tell
I
President...
mean, for picking the wrong Negro and saying, I'm picking him because he's a Negro. I'm opposed to that.
When did you tell President...
I don't see, my dad told me way back that you can't use race. For example, there's no difference between a white snake and a black snake, they'll both bite. So I don't want to use race as an excuse.
So Justice Marshall, obviously using a phrase like the wrong Negro, the snake comment is sort of somewhat well known in this particular part of the story. But you can see this is an individual who has spent his career arguing for access, now making the claim that race should not be an excuse to choose the wrong Negro, which of course I don't think is inconsistent with his career before that, but is forcing him to twist in certain ways. The next clip is from the press conference 4 days later, which is the press conference in which President Bush announces Clarence Thomas as his nominee. And he's asked sort of point blank a question that I think illustrates the extent to which Justice Thomas has faced this kind of doubt in his judicial career and his political career.
Judge, a question for you. What do you say to critics who say the only reason you're being picked is because you're black?
I think a lot worse things have been said. I disagree with that, but I'll have to live with it.
And so here, this is a person who on his, upon sort of reaching the pinnacle of the American legal system is asked about the critics that suggest that the only reason that he is picked is because of his race, and sort of forced to face that in this particular moment, which I think illustrates the power of that particular narrative, that it was a narrative that has existed throughout Justice Thomas's career. So I'm just trying to give a little bit of the flavor of what's going on in the moment in 1991. So I've said earlier, I believe this is the most impactful Supreme Court transition of the past 70 years because of who's involved, because of the ideological gulf between Justice Marshall and Justice Thomas. And I'm going to spend the balance of my time arguing that that ideological gulf comes from sort of a common place, a place in which both Justice Marshall and Justice Thomas define their work as being the work of furthering, expanding, protecting, having the best ideas for stronger Black citizenship, for navigating the relationship between African Americans and government. And so they obviously go in hugely different directions from that common origin, but I think it is that common origin that allows them to represent such a gulf in thought and in jurisprudence on the Supreme Court. Before I talk about the differences, though, I did want to talk a little bit about similarities. And this is a quote from a piece from a familiar name here. If y'all haven't read this, this piece from Dean Onwuachi Willig, you should, if you're interested in this topic, because I think it comes from a very similar place as my own work does. And I think what drove this particular article, and you can please correct me if I'm wrong, was that there was something, even though we think of probably these individuals as vastly different, she recognized, and I think it's undeniable, that both have faced similar criticisms that cannot be explained in any other way other than being motivated by race. These are criticisms about their intellect, criticisms about their capacity to do the job, criticism about whether they were the best person for the position. And the question that was asked there is, what does it mean that the only 2 Black justices to sit on the Supreme Court, 2 justices who could not be any more different, have routinely had their intellectual abilities and individualism questioned in the same way? On that individualism point, both Justice Marshall and Justice Thomas spent many, many years being sort of dismissed as puppets of Justice Brennan or Justice Scalia, as people who couldn't make up their own minds. And that kind of critique, even among people who are very different ideologically, that common critique reveals something about the way we think of these justices and their work. And so part of this project, and I think that the dean's work in this space, was a really early version of this same thing, is to say it's not acceptable to just dismiss intellectually these 2 individuals. Rather, it's time to sort of really dig in and work with dig into their work in a way that is true to their actual intellect and their actual capacity and the actual contributions that they have made. That doesn't mean without critique, but it means in a serious way. And so that is sort of what brings me, that was one of the other kernel that sort of brings me to this particular work, that it's not just that the transition matters, that the personnel matters. It's that this particular transition has probably been underappreciated because the individuals involved have been underestimated intellectually. And so that's where we'd like to go next. So I keep saying this thing that I think it's the most impactful transition in court history, or not in court history, at least in the last 70 years. And so I want to show you something. This is something I have to confess the publisher didn't want you to see. Not because it's particularly controversial, but because they thought people don't, the market for reading this particular information wouldn't be large enough. But here we have law professors and law students and lawyers, and so I'm hoping that you are the kind of people that would find this interesting. And so is anyone familiar with the measurement? I bet several of you are, with Martin Quinn scores of ideological, okay, so some people are nodding. So these researchers have developed the sort of ideological sort of points of different justices on the Supreme Court over years. And they do it each term, and they essentially put justices on a scale where 0 is sort of neutral, negatives are sort of leaning what we would describe as more liberal, and positive numbers are leaning what we would describe as more conservative. And so what I've done, and I actually have a couple of articles that share this data in a lot more detail. Those are the articles that I wrote because the publisher said, don't include all that stuff in the book. And what I've done is looked at all of the transitions since 1953, and using a variety of metrics, this only one of them, but using a variety of metrics, tried to identify which particular transitions made a difference. So one way in which you could judge that, and that's what this particular slide is showing, is by looking at the long-term ideological sort of point of each justice. And so the columns, with the numbers are showing Justice Marshall's average Martin Quinn score over his 24-year career was negative 2.815. Justice Thomas's, as of 2 terms ago, was 3.448, and then just look at the difference. So you can see up here, these were the 5 transitions that had the largest long-term ideological difference between outgoing and incoming justice. And you can see that the difference is the most, so luckily my data confirmed my hypothesis, between the Justice Marshall to Justice Thomas transition. I did want to highlight number 5 on there, which is of course still in the process of developing. This is the Ginsburg for Barrett transition of 2020. And, so we will see. I think that that one is the closest thing to the Marshall to Thomas transition that we have seen, because it, since that particular time, because the Marshall to Thomas transition kind of confirms a long building conservative slant on the court. At the time of his retirement, Justice Marshall was the most recent Democratic appointee on the court, having been appointed in 1967. So it had been exclusively Republican appointees from 1967 until Justice Ginsburg in 1994. And so it was a long transition away from a court that Justice Marshall joined, in which he was actually the median justice, to the point where we are today, in which Justice Barrett's confirmation intervened in that sort of norm that was established with, like, the Justice O'Connors and Kennedys kind of running the center of the court. It's tilting conservative, but somewhat moderate. Justice Barrett's confirmation obviously ushered in a different era in which the numbers on the court, the personnel on the court, are significantly different. And so if there is one that is in the vicinity of impact, then that is the one that I think to keep an eye on. So by other measures, I think it's also the most impactful. I mentioned the way in which it affected who the median justice is, and those median justices, O'Connor and Kennedy, at the sort of center of the court, lasted for so long. That era is ushered in by this particular transition. Just as a side note, I think a lot of people at this particular time wouldn't have known that, because they didn't know two things. One, that Justice Stevens, who's on the court at this particular time, was going to continue sort of moving further and further in the liberal direction. And then Justice Souter, who had just finished his first term on the court, would end up trending liberal as well. Justices Kennedy and O'Connor are also sort of tilting in that direction over time. And so it's Justice Thomas really who confirms that conservative majority, even as other factors are pushing in another direction. So what are the views of these individuals? How did they reach them? The book is a book about people and about ideas. The first portion of the book is all about introducing these characters, Justice Marshall and Justice Thomas, as people. And it focuses a lot on their schooling. Where did they go to school? In part because the second part of the book, which focuses on their ideas, is taken mostly from their writings on schools cases. It's because in schools cases is where you see a lot of the most passionate language that Justice Marshall and Justice Thomas use. In addition, they're often writing in solo concurrences and solo dissents. And so rather than other opinions where they might have had to negotiate with colleagues to include or not include things, we're just getting their statements of their particular opinions. And so the book traces their schooling and their work on schools cases to reveal not just the impact when it comes to race, and not just the impact when it comes to schools cases, but it tries to expand that out more broadly to say these are differences not just in race and schools, but in the relationship of government to people, the relationship of states to the federal government, the relationship of courts vis-a-vis people or government. All of those sort of big American political topics are sort of represented and can be taken from the differences that Justice Marshall and Justice Thomas have on how best to make schooling better for Black students, how better to serve Black citizens in our system. Okay, so I'd like to talk a little bit about that. So Justice Marshall, his vision is one that's born of legalized exclusion, of a life experienced in segregated Baltimore, in schools that are segregated by law. And it's a vision that is also born of a career of litigation. Though perhaps underappreciated as a justice, I think Justice Marshall is rightly appreciated and championed as a lawyer. An unparalleled series of, unparalleled legal career, perhaps more impact on the way in which the Constitution is interpreted as a lawyer as any other lawyer in American history. And so I've chosen here a selection from Justice Marshall's oral argument in Briggs versus Elliott, which is the portion of the Brown case that he argued, the South Carolina case. If you know, that Brown case is a bunch of cases that are consolidated into one. And here we get a sense of where Justice Marshall is coming from. So like I said, his vision is one born of exclusion, where the government has caused the harms, and therefore one where the government is responsible for remedying those harms. And so if the government is the cause of racial disparities and racial discrimination, and the government is the party responsible for that, remedying that, then that leads to a certain vision of what courts should be able to do, what governments should be able to do. So you see Justice Marshall okaying and being okay with government taking aggressive steps to remedy poverty, to remedy discrimination, to remedy other things. Government caused these problems. Government should be given the leeway. I'm willing to allow government the leeway to try to solve them. That shows itself certainly in the circumstances in which Justice Marshall would be willing to apply something less than strict scrutiny when the government is trying to remedy things that the government has caused. So he's willing to defer in those cases, but he's totally unwilling to defer or unwilling to tolerate circumstances that he thinks can be traced back to that prior discrimination. So he sees a very strong causal link between the government action of the past and the disparities, racial or otherwise, of the present. And so he's willing to say that disparity, today's disparity, is caused by the government, and again, is willing to give courts the equitable power to deliver, right, to fix those problems. And so this is Justice Marshall's vision. And so, and he's constantly talking about citizenship. So he weds his vision to not just, these kinds of lawyerly things, but a bigger idea that if this country is going to survive, it's got to survive in a way that every person has access. That without justice, this country isn't surviving. And so while, yes, he is certainly a strong advocate for individuals who are disenfranchised, whether they're Black, poor, religious minorities, unpopular speakers, whatever, he's doing that in service of the idea that this country can't survive if the government isn't providing baseline justice, baseline access for everybody. And so this quote is about the sort of harm that's caused by segregation. I'm not going to read it. If you've read it, great. If not, you can buy the book. Two cases that I think best capture this are two cases from the early 70s. One is San Antonio Schools versus Rodriguez, and the other is Milliken versus Bradley. They're very similar cases that come in a very similar moment, but they're asking very different questions. The Rodriguez case is about whether the Equal Protection Clause can be used to intervene in school funding, where the Texas school funding system led to different districts having vastly different funds available to it. And the Milliken case is a desegregation remedial case about whether the remedy for a Detroit desegregation decree could include suburban Detroit school districts that were not part of the litigation, but had been places in which mostly white families had moved in creating a sort of inter-district segregation within the Detroit metropolitan area. And these two cases, I think, represent Justice Marshall's vision because in both situations, he is willing to not only allow the government to take, and the courts, to take the steps that are needed to remedy these problems. He's actually demanding it. He's saying school funding and the lack of an equal start in life is, unequal funding is leading to an unequal start in life, and that is, that can't be tolerated. That's the government's fault. It's creating unequal lives for our people, and therefore the court not only can intervene, but must intervene. Similarly, if individuals are moving out of Detroit to avoid desegregation or for whatever other reason, it's enabling the same kind of generational harm that legalized segregation was causing, and therefore not just that the court can, but maybe the court must intervene in that situation. So here, we deal here with the right of all of our children, whatever their race, to an equal start in life and to an equal opportunity to reach their full potential as citizens. I would note the right of all of our children is the way in which he's phrased it. Our nation, I fear, will be ill-served by the court's refusal to remedy separate and unequal education, for unless our children begin to learn together, there is little hope that our people will ever learn to live together. That his vision is not just about these students, his vision is about our nation. And so all of that is rooted in this experience in fighting segregation and saying this is something that is toxic to our nation, and that we can't just apply legal rules in a way that allow it to continue. Justice Thomas had a different life experience, a generation behind Justice Marshall. Interestingly, Justice Thomas entered school in first grade the fall after Brown versus Board of Education. And so he, in theory, could have been among the sort of first students to, I'm chuckling because it's so preposterous, but had what happened was the Supreme Court declared segregation unlawful, and the next year there was no more segregation, then Justice Thomas, right now y'all are laughing too, Justice Thomas would have been among the first class to sort of experience that. Justice Thomas grew up in a generation behind, in the South, and in greater poverty than Justice Marshall had. Justice Marshall grew up in segregated Baltimore in a circumstance in which Black Americans in Baltimore were not given the same opportunities as white Americans, but in which the Black Baltimore community was fairly strong and politically not unpowerful. The NAACP's second largest group, second largest chapter, that's the word I'm looking for, was in Baltimore. And Justice Marshall's family is sort of a part of this middle class, though segregated and excluded in a lot of ways, community. Justice Thomas did not grow up in that world. He grew up in the Deep South in a rural circumstance, or at least began in a rural circumstance, and in greater poverty and a generation behind. And so Justice Thomas experiences a world that is created in part by the work of Justice Marshall, but is different than that world. And though he did not experience legalized segregation, Justice Thomas attends segregated Catholic schools through much of his schooling, eventually becoming a sort of first African-American student, or one of the first two African-American students at a high school, a Black Catholic high school, and then spends the remainder of his schooling as a sort of token or extreme minority in predominantly white institutions. I didn't mention this, but perhaps we know Justice Marshall's biography already. Lincoln University and HBCU, Howard Law School, first in his class, and HBCU as well. His entire schooling is in segregated, or at least entirely Black environments. And so Justice Marshall's vision is born of this life of poverty in the Deep South. And it is animated by disillusionment, I would argue. A generation behind, he's seeing the wins of Justice Marshall and many others who are sort of pushing civil rights legislation and civil rights progress and more inclusion, so that they can open doors to places like Holy Cross or Yale Law School for Justice Thomas. He's seeing that experience, and he's not feeling for himself that those are wins. And so there's this disillusionment in the Thomas story. And so rather than a narrative in which the primary way in which to ensure strong Black citizenship is by holding the government responsible for the harms that it has caused, that's Justice Marshall's vision, Justice Thomas comes to a conclusion that the best way to produce strong Black citizenship is to get the government out of people's business. And so it's an extreme, limited or anti-government position that's rooted in his experience that when the government intervenes, the government's relationship to Black Americans over time has been nothing but trouble, protecting slavery, protecting segregation. That there's a skepticism about any time the government is involving itself in Black lives. And that his position is the best way to ensure stronger Black citizenship is more individualistic, less government, and more focused on what he would describe as empowerment. And that's the way. You make strong citizens by allowing them to be citizens without government intervention. So a totally different view. I'd like to note, neither Justice Marshall nor Justice Thomas is entirely consistent. I'm describing a general theme, I think, from their work that I think is fair, but they're not 100% of the time. You can't look at everything that Justice Thomas has ever done and say, oh, well, that can be explained by this idea. And same true for Justice Marshall. And the other thing that I think is really important to emphasize here is that these ideas aren't new and they're not unique to Justice Marshall and Justice Thomas. These are part of centuries of debate about how best to create strong Black citizenship. It's perhaps the most contested question in American constitutional history, right? Like, how do we include people who legally at the outset were enslaved? How do we bring them into full citizenship? And that's not a question that Justice Marshall and Justice Thomas are the first to encounter. There's a long history of thinkers in this space, dating back to the founding of the country, about these two philosophies. And then the last thing I'd like to note is they're not mutually exclusive. It's not the case that Justice Marshall's vision does not also wish for strong Black empowerment and is not also skeptical of government at times. I think there's a healthy skepticism, embedded in that. And similarly, Justice Thomas is not, maybe Justice Thomas, maybe his particular vision might be exclusive of the other vision, but the idea of Black empowerment does not mean that anything goes when the government is involved, right? That those two things are not totally able to be disconnected. So I just want to note that these two series of ideas have been competing throughout American history about solving this particular problem. What makes it unique is that these individuals are giving judicial voice to that, and they're doing it in constitutional cases, and they're doing it from a place of power that very few Americans ever reach. And so they have a unique ability to influence this particular discussion. So if someone like, let's just say, Malcolm X says that affirmative action degrades Black self-esteem, well, that's an idea. I think that's an idea that Malcolm X probably would have agreed with. But it's not an idea that affects the nation's policies with regard to affirmative action. When Justice Thomas would have that idea, he has the ability to influence a Supreme Court decision about whether or not affirmative action is constitutional or not. And so just noting that there's a difference between being a philosopher and being a judge. And while there's a lot of philosophy in Justice Marshall and Justice Thomas's work, they're not philosophers. They're judges that have real life impact. So this particular quote is from an article that Justice Thomas wrote while he was the chair of the EEOC in 1986, before he became a judge. And he's articulating some of his some of the themes that sort of animate his worldview here. I continue to believe that distributing opportunities on the basis of race or gender, whoever the beneficiaries, that's a key clause there, whoever the beneficiaries, turns the law against employment discrimination on its head. Class preferences are an affront to the rights and dignity of individuals. He's always focusing on individuals rather than groups, both those individuals who are directly disadvantaged by them and those who are their supposed beneficiaries. This is a classic Thomas phrasing. Beneficiaries is always qualified as so-called or supposed, the idea being that even where the government seems to be acting on behalf of people, it's doing them harm. This is personal for Justice Thomas. As someone whose life is influenced by affirmative action, who will tell stories about how he was disrespected nonetheless as a Yale Law graduate looking for a job. These are the things that he doesn't feel a benefit. He's calling it a supposed benefit from a program, from a policy like that. The cases that best represent Justice Thomas's philosophy are the affirmative action cases. That's where that personal sort of comes through. I do want to put up one other quote. This one, it's a little long, so I'll just read it, and I think it kind of speaks for itself, but it captures the way in which Justice Thomas weds his highly conservative vision to roots in claims for Black empowerment. So this is from a case of another desegregation remedies case, 1995, Missouri versus Jenkins, in which the court rejected a desegregation plan that was spending a lot of money in the Kansas City schools to sort of equalize them to suburban schools. So it's kind of a follow-up to that Milliken Detroit case. And in fact, if I was talking about the sort of kernels of ideas that gave life to this book, it was teaching in my education course Milliken and Jenkins next to each other, and having Justice Marshall's Milliken dissent and Justice Thomas's Jenkins concurrence taught on like consecutive days or maybe even the same days, and watching my students go, huh, that's interesting. And that kind of reaction, I think, let me see how interesting this particular comparison could be. So here's what he says. Given that desegregation has not produced the predicted leaps forward in Black educational achievement, this is his skepticism of integration, there is no reason to think that Black students cannot learn as well when surrounded by members of their own race as when they are in an integrated environment. Racial isolation itself is not a harm, only state-enforced segregation is. After all, if separation is itself a harm, and if integration therefore is the only way that Blacks can receive a proper education, then there must be something inferior about Blacks. So he's making the claim that integration is not only not working, that's the first sentence, but that is actually rested on, and then he says it directly, to my way of thinking, that conclusion is the result of a jurisprudence based upon a theory of Black inferiority. If we can't survive unless we're in an integrated environment, then there must be something wrong with us. That's the idea that he's putting out there. Totally different than Justice Marshall, whose vision is saying that separation is a toxin for the entire country. And so you see the ways in which they have diverged. I mentioned that the affirmative action cases capture the Justice Thomas ideas most vividly and most personally. A couple months last summer, of course, the position that Justice Thomas has been arguing for so long with regard to affirmative action sort of came to be with the Students for Fair Admissions cases. I just wanted to note that within that case, first of all, I think that case sort of helps represent the way in which the court has changed, right? The full range of impact of the transition from Justice Marshall to Justice Thomas. The principles that Justice Marshall argued for in Brown versus Board of Education were being used to strike down programs that were aimed at the values that underlied the principles that Justice Marshall had articulated in Brown versus Board of Education. So the idea that Brown is used in 2007 and in 2023 to strike down diversity programs suggests the change in the working of the court. Here is Justice Sotomayor reacting to that in her dissent in the Students for Fair Admissions case. Court's recharacterization of Brown is nothing but revisionist history and an affront to the legendary life of Justice Marshall, a great jurist who was a true champion of equal opportunity, not rhetorical flourishes about colorblindness. Haven't mentioned the word colorblindness, but it probably should have in describing Justice Thomas's worldview. And I want to bring us back, as I close here, to Payne. And many of you may know Payne from criminal procedure. Some of you may know Payne from studying Justice Marshall. I know Payne from representing Purvis Payne and from sort of the idea of personnel changing on the court that's captured in that particular idea. But Payne was also featured prominently in the opinion, both majority and dissent, in the Dobbs case, in which Roe versus Wade was overturned. And we could, have a whole other lecture, if y'all want to have me back, about whether Dobbs and Brown are really aligned with one another, as the majority argues. But the dissent also uses Payne, and just uses Justice Marshall's dissent from Payne. And so I was going to put up here one final quote from Justice Marshall and his Payne dissent in 1991, in which he says, "Today's decision charts an unmistakable course. It is but a preview of an even broader and more far-reaching assault upon this court's precedents. Cast aside today are those condemned to face society's ultimate penalty. Tomorrow's victims may be minorities, women, or the indigent. Inevitably, this campaign will squander the authority and the legitimacy of this court as a protector of the powerless." And so this is 1991. And so he is seeing that this particular moment, this particular transition is setting the court on a different course. Some would argue a better course. Others would argue, as Justice Marshall does, a not better course, a worse course. I also think this is a really interesting way in which Justice Marshall ends his judicial career, talking about the authority and legitimacy of the court as a protector of the powerless. No person really had done more as a lawyer to give the court that legitimacy and authority than the arguments that Justice Marshall and his colleagues made during his career. And so in 1991, he is seeing that that court, the court that he helped create, is transitioning into something different. And so I'll stop here. I know there's a little bit of time for questions, so I'd love to hear reactions, feedback, other thoughts. So, yeah. I saw your hand first. I know people have class to get to, so I won't be offended if you leave.
Thank you. That was really interesting, and I also do have class to get to. I just wanted to tell you a story and get your reaction to it. In the summer of 1991, I worked on Thomas's nomination for, just to be oblique, one of the advocacy groups in DC. And I spent a lot of time in the basement of the DOE reading his memos and stuff like that. And I had heard his name earlier and doing some other advocacy work in the mid-'80s in Washington. And at that time, there was a sort of, as you can imagine, there's kind of a coalition of groups that are conversing with one another about the nomination. And when he had been nominated to the DC Circuit, this set of groups had decided not to oppose him, and they didn't oppose him. And in part, it was for the complexities, some of the complexities you're talking about today, which is that people felt his views were still quite unformed. And that it wasn't clear who he was going to become. It was only clear that he didn't support affirmative action, but there was a lot of other complicated things about him and his views at the DOE and at the EEOC. So it was a big decision that summer what the groups were going to do about his nomination. And in the end, some of the groups that were more concerned about race were the ones that pushed the advocacy, not pushed, they were the ones that were most of the view that he needed to be opposed, as compared to advocacy groups with certain kinds of other interests. So again, I'm trying to be oblique about who I was working for, but the fear that the nomination process would push him to the right is different than your chart that kind of shows like he already was the right.
Yeah.
And he already was this thing that was different than Kennedy and whatever. I think people thought he might be Kennedy. And I just wonder what your view is of what the nomination process did in terms of his ideology.
Yeah, well, I mean, I think the first word that comes to mind is disillusionment. So I think it's a fair point in a really interesting thought experiment. What if the confirmation process had been different? What would Justice Thomas have been? And I don't know that I have an answer to that. I've had this weird experience over the last 10 months of being asked questions like this, in which I am like a amateur psychologist of Clarence Thomas, which is a really weird role to play. But so on the direct question, I think that the answer is clearly the process of the confirmation hearings contributed to disillusionment. What you're describing is similar to the complexity that the National Bar Association, the nation's sort of historic black bar, faced with his nominations. What do we do with this? And there's this really extraordinary speech that Justice Thomas gives in 1995, in which he sort of makes this plea that, I'm trying to help, and I have a right, I have a right to my own opinion. And sort of, it's, as far as I can tell, the last real reach out that he makes and says, this is painful to me to be separated out. I'm taking as an assumption that everybody understands the relationship that Clarence Thomas has with the broad majority of African Americans in this country. And so he's describing that it's painful to him that's the dynamic. And I think it's a really extraordinary thing, because it maybe suggests that, with a different approach, maybe there was something there. But I think, if I'm guessing, I don't know Clarence Thomas, so I can't really say. Maybe people in here do, but he strikes me as someone who is extraordinarily stubborn and strong-willed. And I think that even though that speech, I'm drawing from that particular 1995 speech, does express that pain, there is an even stronger sense that I have the right to my own opinion, and that he rejects having opinions assigned to him so strongly that that it's hard to imagine, in any other outcome than the Clarence Thomas that we know. Just as a sort of side note on that front, he has become so closely aligned with political party at this point that it sort of calls into question the independence of I have the right to think for myself, and I always agree with this particular side of things. So that's a critique that I think is worth exploring. But I think that stubbornness is there. The other thing I would like to note is the way in which the complexity played itself out is in the confirmation vote. More Democrats voted to confirm Clarence Thomas than Republicans voted to confirm Ketanji Brown Jackson. And Ketanji Brown Jackson, obviously symbolically of huge import, but the stakes of her confirmation were much lower than the stakes of Justice Thomas replacing Justice Marshall. And it just suggests sort of where we are, that fewer Republicans voted to confirm a overqualified, clerked everywhere, already been a judge at every level, no sort of personal controversy, like as good a nominee as you're going to have. More Democrats voted to confirm an ideological switch and the personal sexual harassment stories. It just shows how powerful that race dynamic was in that particular moment. What are we gonna see? I see all these people. I don't know. Y'all can draw straws. You pick. That's a good idea.
Okay, I'll start. Robert Tsai, how are you? Thanks for joining us. I'm wondering, you made a reference to Malcolm X. I wonder if you accept or you have a adaptation of Corey Robin's theory, which is that Thomas's openness to the uplift aspect of the Black tradition, his openness to Black nationalism as a college student, before he messes around with the Straussians and comes to originalism and so forth. Whether that is really what lands him in the anti-statist libertarian wing of the party anyway.
These are excellent questions. I was not gonna ask because I thought it would just be redundant with Kate's question, but I think there's an additional, on top of just how far Clarence Thomas may have moved to the right, I think it's important to keep in mind the baseline of just how far to the right he's moved in the last 10 years.
Yeah.
And I just wonder if we can if you might think about periodizing. I mean, I think of Scalia having a 1.0, 2.0, 3.0, and I wonder if you might just think about what might have shaped what I perceive to be sort of a Clarence Thomas circuit court judge to then early Thomas, maybe most interested in race, to then just how far to the right he's moved in the last 10 years. And I wonder if you might speculate about, what else might be going on in the last 10 years.
Okay, my question has to do with something that you brought up from our dean's, the quote from our dean's article right at the beginning of the talk, which is, and it was provoked my reaction to a recent podcast about Clarence Thomas. What does he think he's doing or something? And the dean was on that also. And I'm wondering when we're going to get around to psychoanalyzing Alito and Roberts and I guess and Gorsuch. And I wonder if there's something that's inconsistent with this whole focus on his upbringing and how he comes to what kind of person he is, with that beginning of, it's the idea that we're doing exactly what we were condemning.
Is that it? Okay. So thank y'all. So I'm going to start with the last one first, which I think is a fair critique. And I think one thing that I would like to see more of is exactly what you're describing. So John Roberts, I'll just use him as an example. I think that he is currently in the most diverse work environment or life environment that he has ever been in his life, in a situation in which 2 of his 9 colleagues are African American and 1 is a Latina, and 4 are women. And so, like, if you know, I mean, I don't want to turn this into a John Roberts biography, but like John Roberts's views on what is and isn't appropriate are informed by his life in the same way. So I take the point wholeheartedly. What I would love to see, and I've thought about, and so if anybody wants to do this and push me along the way, is organizing like some sort of ALS discussion group about like, when do justices' personal lives influence their decisions? So like sometimes we talk about Justice Jackson in Youngstown and presidential power, and he's been an attorney general, and so there's that kind of biography. But I think it also goes to like other people's like upbringing and schooling and things like that. So I think that's totally legitimate. And I think that I will say, in the context of the recent reporting, which kind of connects to some of the other questions regarding Justice Thomas and his relationship with Republican donors, that the focus hasn't been on other justices. Maybe that's because this is the only place where that happens, but I feel, and y'all can probably tell where my leanings are in this space, right? So I tend to take more, align myself more with the work of Justice Marshall than the work of Justice Thomas. However, I think that there is, a special set of critique that is assigned to Justice Thomas that is not assigned elsewhere, that is rooted in these same kind of ideas. And I think, fair point, maybe this book contributes to it, right? Maybe I've picked two of the three, the first two, African-American justices to discuss, and I haven't written the sort of John Roberts, Elena Kagan book, which I think maybe would be interesting, although that's not a transition, but just sort of picking a pair. So I take the point. On the periodizing, I think for me there is a break, and this is just because my space is education. The 2007 Parents Involved in Community Schools case is the time at which Justice Thomas stops grappling with this stuff and starts implementing, if that makes sense. And so a lot of the opinions that you see from Justice Thomas, even before, so like I'll use Shelby County versus Holder, which is essentially a Thomas opinion from a few years earlier, just now the majority opinion. And so I think that the courts movement is what's enabling Thomas to not just be in these solo dissents, but have his old solo dissents become majority opinions. And so I think that's actually an interesting idea. Like if this book weren't trying to be about both justices, then I think it makes sense to think of Justice Thomas in different moments. And I think that sort of raises the what if questions. What if things had gone, a big what if question is, what if Merrick Garland and not Gorsuch? Then what do we get from Thomas over the last 6 years or something like that? So I think that that's interesting. The book, I don't think, to your point, I don't think the book could be written without the ideas of like the Robbins book, and that there's already like this reporting about Justice Thomas's flirtation with Black nationalism, his embrace perhaps of Black nationalism in the 70s. I sometimes get myself into trouble when I am talking about Justice Thomas, because I will often preface comments with Justice Thomas claims blah, 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 in a way that I don't often do for Justice Marshall. And that's largely because a lot of the perspective that we have on Justice Thomas is coming directly from Justice Thomas in a way that Justice Marshall, we don't have an autobiography or a memoir or a documentary or or the same kind of thing. We have historical reporting for Justice Marshall in a way that is different for Justice Thomas. And so the reason it sometimes gets me into trouble is because people will say, well, are you delegitimizing what he's claiming, right? Are you saying, well, Justice Thomas claims that he says that he believes blah, 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 as opposed to Justice Thomas believes blah, 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 blah. You see the slight difference there. And I think one challenge with Justice Thomas is that it's hard to dissociate what he claims from from what happened or what he was thinking at the time. So for example, that's the story he tells about Black nationalism and disillusionment, which I think that there is certainly a true story in there somewhere. But is it self-serving? Is it a story that we just accept in good faith? In large part, this book accepts those stories accepts them in good faith. I think it's legitimate to question those things, right? To say, like, is Justice Thomas or the apparatus around him telling that story for a particular reason in this particular moment. I don't know. I tend to, I thought that the Robbins book was important, and you know, and also I think just, you know, Professor Kennedy's work in that space as well is illuminating in sort of what the reactions are. I think we're out of formal time, but I would like to make myself informally available for as long as anybody wants to be here. I really do appreciate the invitation, and hope this has been interesting for you guys. It's really been a treat for me. So thank you so much.